Good morning, or good afternoon. I keep wanting to say morning also. Well, good afternoon. This is a special call meeting for December 28th, it's 1 p.m. Of the Dougherty County Joint Board of Registrations and Elections. And so at this time, we will call this meeting to order. Part 2 on our agenda is the explanation for the meeting. The Albany-Dougherty County Joint Board of Elections, Registration and Elections will hold a special call meeting to determine if probable cause exists for the following received challenges regarding Dougherty County voters list. Number 1, Mr. Stephen Brimberry challenging the eligibility of approximately 960 voters on the Dougherty County's voters list. And number 2, Ms. Billy Joe Fletcher challenging the eligibility of approximately 2,381 voters on the Dougherty County voters list. To help the board with this, we will hear from our attorney, Mr. Spencer Lee, and he will come and give us a presentation. For the benefit of the audience, there will be no public comment at this particular meeting.
Thank you, Mr. Chairman, and members of the Dougherty County Board of Registrations and Elections. For the record, I'm Spencer Lee, and I represent Dougherty County. But in addition to that, I represent this board. Also, in representing this board along with me on this particular issue is Kenneth Robin. I think most of you are familiar with Attorney Robin. Attorney Robin lives in Cumming, Georgia, and he's with the law firm of Gerard and Davis. This law firm is totally familiar with this issue, as they have representing now several counties relative to the challenges that have been made. And Mr. Robin, I think, is here on the telephone. Ken, are you available?
I'm here. Can you hear me?
He's here, so he's available for any questions that you might have of Ken Robin, the attorney from Cumming, Georgia. I think the best way to proceed with this is to sort of set the issue up for you, and then you can have the discussion that you might want to have relative to this issue. I noted that there are 3 board members present. Is there another board member present through the telephone?
Yeah, I think Mr. Simmons is on. Mr. Simmons, would you?
Sir, I'm here.
Okay, yeah.
So we have 4 members present, and I'm
Correct.
assuming we're short 1 member that's been appointed by the City Commission to take office on January 1 for a 2-year term. Is that correct, Mr. Chairman?
That is correct, Mr.
Okay.
Lee. Thank you.
Is this on? Okay. We're looking at the slide presentation that was prepared by Ken Robin through deliberations with me. The first thing you see there is Albany-Dougherty County Joint Board of Registration and Elections with this meeting that the chairman has set up a few minutes ago. You have a hard copy of this in front of you, the board members do. It's the Georgia Voter Challenges is what we're here for today. This is the challenge itself. On December 17, 2020, Dougherty County elector Stephen Brimberry submitted via FedEx a challenge to the eligibility of approximately 960 electors on Dougherty County's voter registration list to vote in the January 5, 2021 runoff election under Official Code of Georgia Annotated Section 21-2-230. That's one challenge. The second challenge on December 18, 2020, Dougherty County elector Billy Joe Fletcher submitted via email a challenge to the eligibility of approximately 2,381 electors on Dougherty County's voter registration list to vote in the January 5, 2021 runoff election under OCGA Section 21-2-230. Now, with respect to the 960 electors who are the subject of Mr. Brimberry's challenge and the 2,381 electors who are the subject of Ms. Fletcher's challenge, collectively called the challenged electors, The allegations are as follows. You have letters from Mr. Brimberry and Ms. Fletcher. Mr. Brimberry says, I believe that each of the individuals named on the attached thumb drive has, as a result of registering their name and change of address to a location outside of Dougherty County, removed to another state with the intention of making the new state their residence. So what he's saying is, and what's before you, is a list that he's presented for 963 or however many he said there, that's moved to another state with the intention, he says, of making the new state their residence. Thus, each individual has lost their residence in Dougherty County, and consequently, each individual ineligible to vote in Dougherty County. Ms. Fletcher's challenge: available data from the United States Postal Service National Change of Address, NCOA, and other commercial available sources demonstrates probable cause to believe the individuals no longer reside where they are registered to vote. In fact, these electors appear to have permanently established other residents as reflected in the change of address to residential addresses outside of the Georgia county in which they are currently registered voters. So in sum, the challenges and what you're looking at today, the challenges are alleging that the challenged electors are ineligible to vote in the January 5, 2021 runoff election because they are no longer residents of Dougherty County. The challenges are based upon the challenged electors' names appearing in the National Change of Address database, the NCOA, maintained by the United States Postal Service, USPS. The NCOA database is a database maintained by the United States Postal Service, which includes records constituting of the names and addresses of individuals who have filed a change of address with the United States Postal Service. The challenges allege that because the challenged voters' names appear in the database, then they are no longer residents of Dougherty County and therefore are not eligible to vote in the January 5 runoff election. The challenges are brought under OCGA Section 21-2-230, which permits an elector of a county to challenge the right of another elector in the county whose name appears on the list of electors to vote in an election. A challenge must be in writing and specify distinctly the grounds of the challenge. After receiving a challenge, the Board of Registration and Elections shall immediately consider the challenge and determine whether probable cause exists to sustain the challenge. And of course, that's why you're here today, to determine whether or not probable cause, as shown by the challenge by the two electors, exists to sustain the challenge. If the board finds there is no probable cause, then the challenge is denied and no further action is needed. If the board finds there is probable cause, then the board shall notify poll workers at the challenged elector's precinct, poll workers at the absentee ballot precinct, and, if practical, notify the challenged elector and afford such elector an opportunity to answer. And any challenged elector that appears at a polling place to vote shall be given the opportunity to appear before the board to answer the grounds of the challenge. If any challenged elector casts an absentee ballot, then the absentee ballot shall be treated as a challenge ballot pursuant to OCGA Section 21-2-386. And if the challenged elector does not cast any ballot, then the challenged elector is entitled to a hearing in accordance with another code section, 21-2-229. Probable cause. That's what you're here today to determine. After receiving a challenge, the Board of Voter Registrations and Elections shall immediately consider the challenge and determine whether there is probable cause to sustain the challenge. Probable cause is defined to be the existence of such facts and circumstances as would excite the belief in a reasonable mind that the facts alleged are true. Probable cause is something more than mere suspicion, but less than prima facie proof. Suspicion, speculation, or conjecture is not sufficient to show probable cause. For purposes of registering and qualifying to vote, residence means domicile. Domicile means residence and an intent to remain. One can have several residences, but only one domicile. The residence of any person shall be held to be in that place in which such person's habitation is fixed without any present intention of moving therefrom. In determining a voter's qualification to register and vote, the initial registration, the registrars to whom such application is made shall consider, in addition to the applicant's expressed intent, any relevant circumstances determining the applicant's residence. The registrars taking such registration may consider the applicant's financial independence, business pursuits, employment, income sources, residence for income tax purposes, age, marital status, residence of parents, spouse, and children, if any, leaseholds, sites of personal and real property owned by the applicant, motor vehicle and other personal property registration, and other such factors that the registrars may reasonably deem necessary to determine the qualification of an applicant to vote in a primary or election. A person does not lose residency if he or she leaves his or her home for temporary purposes only with the intention of returning, unless such person shall register to vote or perform other acts indicating a desire to change such person's citizenship and residence, such as students enrolled in college, university, or other educational institution in Georgia do not lose their home residency while at school. Person who moves to D.C., a federal territory, other state, or foreign country to engage in government service does not lose residency during that period of service. There must be either the tacit or the explicit intention to change one's domicile before there is a change of legal residence. If a person leaves the place of his domicile temporarily or for a particular purpose and does not take up actual residence elsewhere with the avowed intention of making a change in his domicile, he will not be considered as having changed his domicile. Let's talk a second about the National Voter Registration Act. The National Voter Registration Act prohibits within 90 days prior to a federal election any program, the purpose of which is to systematically remove the names of ineligible voters from the official list of eligible voters. A systematic program does not rely upon individualized information or investigation to determine which names from the voters' registry to remove. Rather, uses a mass computerized data matching process to compare the voters' rolls with other state and federal databases, followed by a mailing of notices. OCGA 21-2-230 is not intended to be a systematic program, but instead an individualized program. Further, each voter will be permitted to cast a provisional ballot and have the opportunity to appear before his board to establish residency. Finally, the purpose of OCGA 21-230 is not to purge a voter list, but to identify individuals not qualified for whatever reason to vote in a particular election. National Voter Registration Act and the Voting Rights Act. A number of groups have submitted demands throughout the state asserting that based on the timing of the challenges within a few weeks of the January 5 runoff election and the form of the challenges related to eligibility of a mass listing of persons appearing on an NCOA list, there would be violations of the National Voting Rights Act and sections of the Voting Rights Act, National Voting Registration Act, and sections of the Voting Rights Act. If those challenges were upheld through a determination that probable cause exists, these groups argue that there may be a Voting Rights Act violation if it were determined that the timing and form of these challenges amounted to unlawful voter intimidation prohibited by the VRA. At least one lawsuit has been filed in Georgia asserting the application of OCGA 21-2-230 at this stage that the election violates the National Voter Registration Act. Now, I'm familiar with only 2 cases that have been filed, and we really don't need to discuss those cases because that's not why you're here. You're not here to discuss those cases. You're here to make a determination as to whether there's probable cause based on the information that's sent to you. But those cases, or one of them is going to be heard in Dougherty County Wednesday at some time during the day. And that's been filed in the Middle District of Georgia with the Albany Division against against Muskogee County and Ben Hill County. Another one has been filed in Atlanta in the Northern District against True the Vote organization that's obviously been involved throughout the state. So those are the only 2 that I'm aware of that have been filed. But again, we don't need to be getting into whether one side prevails in those or not. The issue before you is whether that there's probable cause based on the information you have to sustain the challenge. The National Voter Registration Act, in particular, following a determination that probable cause exists, that's the same kind of electoral challenges by 2 separate county boards of election. A lawsuit seeking a declaratory judgment and injunctive relief has now been filed in the Middle District of Georgia, asserting a violation of the National Voter Registration Act against the members of those 2 counties and the Board of Elections. That's the one that's being held in the Albany Division and will be litigated and heard at a hearing this coming Wednesday here in Dougherty County. Voting Rights Act. A separate lawsuit has been filed against an organization alleged to have recruited electors in numerous counties around the state to submit these types of electoral challenges, as well as certain of the individuals who have submitted these electoral challenges, contending that the organization and the electors submitting these challenges are in violation of a section of the Voting Rights Act. The lawsuit alleges that actions that include the challenging of the eligibility of hundreds of thousands of Georgians to vote in counties throughout the state, and so on. That's the second lawsuit. Now, you've also received letters from organizations that are saying that we will represent you or we will sue you. I think no matter what you do today, we are going to be sued. And I think we may be sued quickly or we may be sued after the election. If the election is a close one, as you know, they may come back with these lawsuits. There's nothing we can do about that. We don't have to deal with those threats from lawyers and organizations about representing us or whatever. We don't have to deal with these 2 cases that we're talking about right now. The challenges allege that the challenged electors, approximately 960 in one and approximately 2,381 in the other, are ineligible to vote in the January 5, 2021 runoff election because they are no longer residents of Dougherty County. That's the challenge in front of you, and that's what you've got to determine based on the information presented to you, whether there's probable cause to sustain that challenge. Your duty is to consider the challenge and determine whether there's probable cause to sustain the challenge. Are there reasonable grounds to cause a reasonable mind to believe that all these challenged electors are no longer residents of Dougherty County? Keep it in mind that suspicion, speculation, or conjecture are not sufficient to establish probable cause. So the spreadsheet that you have in front of you attached to the respective challenges that was submitted to you through the 2 challenges. One of them contains 960 names on one and 2,381 names on the other, and they purport to be pulled from the NCOA database. The question before you, can you confirm these are not just common names with electors? Is it accurate, current, genuine. Second, as to the electors on the spreadsheet, shows a change of address. Do you know and will you consider if the elector temporarily moved, intends to return, has in fact returned? As to the electors on the spreadsheet, shows a change of address. Do you know if the elector was a student or engaged in government service? Are there reasonable grounds to cause a reasonable mind to believe that all these electors are no longer residents of Dougherty County? And that's the issue before you today. Simply probable cause based only on the information that you have in front of you that was submitted to you by the challengers. Now, Mr. Chairman, that's what I have right now. I'll try to answer any questions, and Ken Robbins on the line.
Okay. Thank you, Mr. Lee. Are there any questions from board members? Going once.
Well, that makes my job easy. I don't have to say anything else.
That means you did an excellent job, I guess.
So, Mr. Chairman, the job in front of you today is to make a determination one way or the other as to whether or not there's probable cause to sustain the challenge based on the information in front of you. You have it in front of you. Not to consider all of the extraneous information of possible lawsuits from one party or the other.
Okay. Thank you, Mr. Lee. All right. Board members, we have a decision to make as it pertains to this. If there are no more questions for Mr. Lee, is there a question?
I'm trying to.
You wouldn't help me with pulling that down.
There we
would you?
go. Can you hear me? It seems since we just got this information, we really don't have enough to individually consider each case as we're called to do. The time it would take to decide. And they seem to be individual challenges, even though they've been grouped together in a file, they're individual challenges, so we wouldn't deal with them in the same manner, it seems.
Well, I can quickly answer, I think, where you're going. The burden is not on you to go find additional information. The burden is on the challenger to present the information distinctly in a letter to you and show you that there's additional information. The burden is not on you to go look up things and go seek additional information. We're here today only on the information that the challengers presented, and you have that in front of you. And if you feel like that information gives you probable cause to sustain the challenge, then that's how you vote.
Isn't a challenge under the other way, where they're challenging the presence on a list or the right to be registered, where you have a hearing and you give the voter a chance to come?
Well, of course,
This
this section doesn't call for a hearing. The Section 229 calls for a hearing. Section 230 does not call for a hearing. It just calls for you to meet and make a decision based on the information in front of you, whether you think there's probable cause to sustain the challenge.
Yeah, and we just got this information. Okay.
All right, thank you, Mr. Lee. I think your explanations is pretty clear. I think just based on the information that we received, and we do have it in front of us, that just a generated list from the National Change of Address Registry probably is not within itself sufficient evidence to support these challenges. That's my position based on just the evidence that is presented. So at this time, I would either entertain a motion to receive the list or reject the list. I can't make the motion.
I offer the motion that we reject the list that's been presented.
On the grounds that you find no probable cause.
On the grounds that there's no probable cause.
I second that motion. So we're going to call for a vote.
Let's repeat the motion, and what was the motion?
The motion is that we, as a board, reject the two lists that were presented on the grounds that there's no probable cause. Any other discussion? So we'll call for the question. All those in favor of the motion, aye.
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 All opposed, nay.
Nay.
All right, thank you. The motion passes 3-1. Thank you all for your time. Thank you, Mr. Lee. Thank you, concerned citizens, for being here today. This will end this meeting. This meeting is now adjourned. Thank you.